So now I welcome our next two speakers, another former dean, Larry Kramer, who was my next door neighbor years ago, and we were both newly minted assistant professors at the University of Chicago. And upon leaving the deanship here, he became the head of the Hewlett Foundation, where he is still presiding. Jane Schacter, who is a beloved law professor here at Stanford, teaching the course as we speak, and is also especially an expert on some of the subjects that John Hart Ely touched upon. So Larry, Jane, welcome. Thank you.
Great. Thank you so much. It's really a pleasure to be here and be with everyone to talk about this. This is the third Ely Symposium I've been part of. One was here at Stanford Law School back in 2004, and the other was another 40th anniversary that got delayed by COVID, and we never actually got to meet in person. So I'm glad that we are here together today. I feel a special connection to the book. I was a 1L in the fall of 1981, and the book had recently come out, and my mentor, who was a political science professor at Michigan, handed it to me and said, "This is what you need to know." And it has really kind of framed an intellectual agenda for me ever since. And I guess the only downside of the gift is I thought that all legal scholarship was going to be written with that kind of panache and wit, and needless to say, no. So, you know, the book has been just an incredible magnet for scholarly attention. When I wrote a piece for the other symposium in the fall and looked at the citation counts, the book has been cited over 6,500 times in law reviews and in 1,200 books. And there's no sign of that letting up, even with the ascent of constitutional originalism. 600 law review sites in the last 5 years, and it remains a staple of constitutional law casebooks and courses. And I mean, that's an impressively enduring impact by any measure. So I want to look at Ely and specifically representation reinforcement through the lens of state constitutional law, and suggest there's some larger insights there. And there's been really very little written about Ely in that domain. And traditionally, state constitutions and state courts, of course, have not been at the center of constitutional scholarship, to put it mildly. But only a few years before Democracy in Distress, Justice Brennan wrote an article in the Harvard Law Review, and it is one of the most cited law review articles of all time, State Constitutions and the Protection of Individual Rights. And in it, Justice Brennan kind of issued a clarion call for state courts to pick up the mantle of the Warren Court as he saw those cases slipping away in the Burger Court. More recently, Judge Jeffrey Sutton on the Sixth Circuit has written a terrific book, 51 Imperfect Solutions, States in the Making of American Constitutional Law, a plea, again, for increased attention by lawyers and scholars to what's going on in state courts. His is not in the same ideological register as Brennan. His is really a plea for federalism and the value of kind of judicial laboratories of experimentation. And of course, if the tea leaves are correct, for example, on the subject of abortion that we were just talking about, there's going to be a lot more attention on state courts and state constitutions on really high-profile issues like abortion. And I'll just say quickly, as an aside, that I taught a course in state constitutional law for the first time this past fall. Had a really big enrollment by Stanford Law School standards, and it was really fun and interesting and engaging, I think, for me anyway. So state courts are a somewhat improbable place to look for any major footprint by Ely for a couple of reasons. One is the kind of, high priests of academic constitutional law are not much in evidence in state courts. I mean, state courts have enormous dockets, towering over the dockets of federal courts, and especially the Supreme Court. They're busy, they're pragmatic, they're not, too oriented toward constitutional scholarship. To some degree, that's true of federal judges as well. There are some more academically oriented federal judges, and of course, on the Supreme Court, you're more likely to see engagement with some scholarship. But the second reason is that a key kind of structural principle of Ely's was that life tenure was going to insulate judges from the political process. And more than that, it was going to allow them to stand apart from the political process and be free of the biases and prejudices that affect the political process and that work to the disadvantage of minorities. Now, that has hardly proven true on the federal side. Federal judges really are not, I think, by and large, enthusiastic representation reinforcers, although I will talk about places in the doctrine where it's had an impact. But the fact that many state judges in 39 states, judges have to face the voters at some point or face some kind of political accountability, that would seem to throw a monkey wrench into Ely's theory. So I want to describe what I called in the piece, glimpses of representation reinforcement. I could have called it traces or, hints. There's no strong sort of theme of representation reinforcement, but I did find some, I think, interesting episodes in which state courts using state constitutions have applied ideas drawn from the idea of representation reinforcement, not always explicitly, but in that general conceptual neighborhood. And I think focusing on them might have some theoretical payoff for thinking about some of where Ely succeeded and some of where he failed. So the first category and the clearest and most extensive set of cases concern school funding inequalities. So in the early 1970s, 71, I think it was, or 72, the Supreme Court in the San Antonio case said, we are not, when confronted with radically disparate funding, poor districts and rich districts there in the state of Texas, we're not going to use equal protection to take any kind of a close look at that. And basically, education is left to the states. And the states have really picked up that mantle, the state courts. And many of them have ruled, there have been hundreds of cases, and many of them have ruled in favor of plaintiffs who challenge school funding inequalities as inconsistent with the state constitution. Now, the state constitutions often have education clauses, which is different from the equal protection clause. On the other hand, many of them are extremely vaguely and open-endedly written. So you have the same challenge that Ely was confronted with, of what principle should courts use with this kind of open-textured language. And there have been significant victories in that domain, by no means all. And I think over time, state courts have become more resistant to robust remedial relief. But there have been a number of victories. Sometimes the courts are talking about discrete and insular minorities, and think about it. Kids who are being taught in underfunded districts have two kind of political deficiencies. They themselves can't vote, and their parents are, by and large, politically powerless. So that really fits the model, I think, pretty well. Second category is the same-sex marriage cases. And, we all know about Obergefell in 2015, but the same-sex marriage debate started way earlier than that. It started in Hawaii in 1993 with the Hawaii Constitution, and then it went to Vermont with its constitution, Massachusetts, and a number of other states, Connecticut, Maryland, Washington, others. And what the courts in those cases did, they tended to borrow the equal protection methodology from the federal context and engage in a kind of tiers of scrutiny inquiry and ask, well, should sexual orientation, should classifications that disadvantage based on sexual orientation be subject to heightened scrutiny? And the Supreme Court had said, starting in the 1970s, that one of the main criteria for heightening scrutiny was the group had to be politically powerless. And that's just a direct line to Ely. Now, Ely didn't invent that idea. We talked about footnote 4 in the 1930s. The Supreme Court started to develop this jurisprudence in the 70s before the book came out. But he really kind of consolidated and rationalized and sort of made the best case, I think, for the principle. So these state Supreme Courts are using federal doctrine about heightened scrutiny, and they're struggling with this question: are LGBTQ folks politically powerless? And in many states, there had been successes, not marriage equality, but successes with anti-discrimination law. And in other states, none at all. But here were a number of courts ruling in favor of marriage equality, and many of them heightening scrutiny and using this kind of Elias principle. The third category that I looked at has to do with the issue of fines, fees, and bail, and the excessive version of all of those things in state courts. And this issue has taken on a newly high profile from the time of Ferguson, where we really, I think, started to understand how excessive criminal justice fees and fines could tether people to the criminal justice system for long periods of time, and it inspired concepts like the criminalization of poverty and cash registered justice. And interestingly, state courts across the country, and not always in the states where you would predict it, became interested in this. And many of them used their administrative powers, not the power of judicial review, but their administrative powers to say there are people who don't have equal access to the criminal justice system, or there are people whose life chances are being completely subverted by these excessive fines. And so that's another example. And then sometimes it's more traditional judicial review. Our beloved former colleague Tino Cuellar, while he was still a justice on the California Supreme Court, wrote a landmark ruling last spring, severely restricting the use of cash bail in California under the state constitution, and sounding some of the similar themes. So what might this tell us about representation, reinforcement, and constitutional theory more generally? So I want to focus on one point. The idea of representation reinforcement was conceived by Ely as procedural, as value neutral, as a way out of the quagmire of courts having to make contested issues about fundamental rights. And from an early point, this claim rightly came under criticism. I'm so happy that Paul Brest is here today, because he wrote one of the first articles making this point, The Substance of Process. And Larry Tribe wrote an article around the same time, made the same point, that you need substantive values to operationalize a theory about democracy, to say what democracy requires, to say what's a malfunction and why, to specify which groups qualify and which don't, right? And so that loops back to some of what Kathleen and Jenny were talking about. So what I see in the state context is that in many ways, these cases, although they resonate with themes that Ely sounded, are better understood as reflecting particular substantive theories of equality. Not value-neutral proceduralism, but substantive theories about equality. And they're better seen as judgments about the groups than about the operation of the political process, strictly speaking. And the same-sex marriage litigation has one really great example of this. In many of the state marriage equality cases that led up to Obergefell, the places where the plaintiffs were winning and often getting heightened scrutiny were the states that had passed anti-discrimination laws, where there had been political successes. By contrast, the states which would never pass a non-discrimination law, including sexual orientation, were also places where there was just no chance of winning a marriage equality case. Right? It's kind of paradoxical, and it kind of turns some of Ely's idea upside down. And this sort of thing is not limited to the domain of state courts. For example, in the preamble to the Americans with Disabilities Act, passed in 1990, there's an explicit reference, with no apparent irony, to the idea that people with disabilities are politically powerless. Right? So really, that idea, I think, is standing in, not for procedural claims about the political process, but for a larger idea about inequality. And I think that state courts can find in their state constitution or not protection for that kind of inequality. It is better understood that way than as, strictly speaking, a sort of representation reinforcement in its original form. Last point, but kind of an important one, I think, and a difficult one. Over time, I mentioned the fact that one of the reasons why representation reinforcement doesn't really fit in state courts is that so many judges are elected. And over time, those elections have become much more salient, subject to much higher campaign spending. And like everything else in our politics, you know, they have their problems, unequal spending, you know, negative advertising run amok that doesn't have a lot to do with substance. But one thing they also have in common with our other elections is they've become nationalized in the way that other state and local elections have. So if you look at voting for state Supreme Court justices, there's a high correlation between presidential vote choice and in a system that uses partisan elections, the voter choice about the Supreme Court justice. And even where they don't have a clear D or R next to their name, usually the endorsements, the advertisements in a contested election, there's a lot of sleepy state court elections, but fewer than there used to be. And even in those nominally nonpartisan elections, there is a correlation, not as strong as in the partisan, there is a correlation with presidential vote choice. So these elections are becoming more and more about, you know, progressive justices, conservative justices. And you can see, to go back to the idea of glimpses or traces, you can see when you look at the election materials in some of these cases that the themes also resonate with national themes. They resonate with themes that we're probably going to hear something about in the confirmation hearing for Judge Jackson, right? The progressive liberal candidates are likely to talk a little more about equality, access to justice, sometimes issues in the criminal justice system. The conservative candidates and their platforms are much more likely to talk about not legislating from the bench and applying the laws written, you know, which broadly speaking resonates with kind of different jurisprudential approaches. Now, maybe these elections offer some version of what my friend Larry has taught me about, popular constitutionalism. I don't think it's Larry's preferred version of popular constitutionalism. I think he likes a more Madisonian version. But I think there might be something to that what we see is justices in the state domain who are friendly, broadly speaking, to representation reinforcement are able, in fact, to run on that in some states. They're not going to run that way in Texas, which is thought to be the most conservative state Supreme Court. They might run that way in Vermont, which is at the other end of the spectrum, right? So I'm sort of playing the role of the vulgar realist here, and constitutional theory is politics. But in this context, I think it gives us something. It gives us something to think about. Leave it there, Larry.
Thanks, Jane. So I'll start with two quick prefatory notes because I feel my own first encounter with democracy and distrust, also when I was a law student, my third year in 1984. By the way, here's why this occurred to me, because I went and dug the book out, before this, and I have my original copy, and like the bottom half of it is all crinkly and wrinkled, and I had this vivid memory. It was my third year in law school. I was taking a reading class with Cass Sunstein, and for some reason, this is in the TMI category, I was reading it in the bathtub, and I dropped it into the water, and so it still has all those little wrinklies. And I, of course, prepared this talk on my own. I didn't really, compare notes with everybody else. So this may be a little different in the sense that I thought to myself, this is a kind of I come to bury, not praise, John Hart Ely, although not in the sense of criticizing the substance of the theory, but in the sense of I want to focus on one aspect of it, which has been touched on, which is its aspirations to be a comprehensive theory, right? That is a constitutional theory in that sense, an overarching normative principle for interpreting the Constitution. First, is a really recent phenomenon. So again, I'm not talking about the use of arguments in particular discrete cases on a one-off basis, but somebody's claim to really want to provide an overarching approach to interpreting the Constitution, across clauses and provisions. And it may surprise at least the students here But constitutional theory of that form, right, the form Ely offers in Democracy and Distrust, or the form offered by, Alexander Bickel, Ronald Dworkin, Robert Bork, Nino Scalia, Bruce Ackerman, and scores of other scholars, all in this period around when we were in law school, is actually just a byproduct of the Warren Court. More on that in a moment. It's a short-lived one, too, though, because it essentially died in the 1990s. A friend of mine used to say about Ely's book that it was the most widely praised and cited and least used book in the con law canon. And that description, though, turns out actually to apply to the whole canon, with one exception, which is originalism, and I'll come back to that, too. So to understand this, I want to go back to the American Revolution. All things go back to the American Revolution, which produced what are often inaccurately described as the first written constitutions. So why is that inaccurate? Because the idea of a constitution was not new in 1776. American settlers had lived under what they self-consciously viewed as their constitution since the first settlements in the 17th century, constitution they brought with them. Indeed, they rebelled in defense of that constitution, fed up with, as Jefferson wrote in the Declaration, a history of repeated injuries and usurpations by the king and parliament, which kept violating its terms, at least as the Americans understood those terms. And that British Constitution incorporated a whole lot of written texts, Magna Carta, statutes like the Declaration of Rights of 1689, the Acts of Settlement of 1701, prominent treatises, especially those of Vattel, Pufendorf, and Grotius, certain philosophical works, of which John Locke's were probably the most important. And all those texts, alongside other sources, including parts of the common law, and a whole lot of traditions and practices and customs, provided a coherent body of fundamental law that Americans had been interpreting and enforcing for more than 150 years before the Revolution. So if they already had a constitution, one they were willing to fight a war to preserve, why did they write new ones? And the answer is that doing so became a legal and practical necessity after independence was declared. Right? By declaring independence, Americans abrogated their existing constitutions, not just the imperial constitution that governed their relations with England, but also each individual colony's internal constitution, which rested on authority granted by the crown. So the initial reason for writing constitutions then was simply to fill gaps created by renouncing allegiance to the king. It followed that the first and main order of business was to fill those gaps, establishing the basic structures of government, new legislatures, new executives, new judiciaries, which is what the new constitutions mostly did. A few states added declarations of rights, others embedded some rights in their texts, which was basically to clearly spell out fundamental liberties Great Britain had tried to deprive them of. And while they were structuring institutions, they tried a lot of experiments in new modeling their government, things that had been mooted during the revolutionary and pre-revolutionary, in the pamphlet literature of the time, but hadn't been tried in practice, and they tried a bunch of them out. So while Americans didn't set out to create something new was what they got. Centralized texts, as opposed to a dispersion of different kinds of texts, centralized texts that contained most of their governing constitutions. Quick aside, by the way, most, but not all. Right? Significant parts of the customary constitution remained, parts that had never depended on the crown for authority and so weren't abrogated by the Declaration of Independence. Most important were individual rights, which is why most states, not to mention the Constitution drafted in Philadelphia, did not include a Bill of Rights. They didn't need them. And why the puzzling Ninth Amendment wasn't puzzling to people at the time. It made clear that the Constitution did not, by silence, abrogate those familiar customary rights. Still, while not comprising the entire Constitution, the new texts were seen to contain most of it and its most important parts. And nor was that all, because the written constitutions were considerably more explicit and vastly more detailed than the written sources of the customary constitution. So one consequence of that was the emergence of judicial review. Now, how that idea emerged, subject for a different talk. But a second consequence was the emergence of questions about how to interpret the constitutions, what rules to apply. Were they like other forms of written law, statutes, treaties, contracts? Or were they sui generis and subject to new rules of interpretation? The question wasn't actually phrased that way at the time. There was no formal structured debate about interpreting the new constitutions. It came up in contexts. So in the early decades of the country, there were just a whole lot of different techniques being employed by different interpreters. All the familiar moves of today are already there, right? From relying on the intent of the drafters to using rules applied to contracts, statutes, and treatises. And over time, these gradually settled into a generally shared, and I just want to underscore, very flexible practice. Ted White wrote about this in his Holmes devised volume on the Marshall Court. As he explains, it took until the early 1820s for things to settle, And what settled was not some distinctive theory or method for interpreting the Constitution. It was rather an investigatory forensic process that offered a broad range of interpretive tools that could be applied to the interpretation of legal texts generally. Put another way, what emerged was a kind of all things considered approach in which interpreters could and did look in an open-ended and relatively unstructured way at text, history, purpose, precedent, past practice, structure, and so forth, from which they would develop an argument for what they thought the best interpretation was. Now you can see this, you see it in the opinions, but you can see it really clearly spelled out in the period's leading academic treatment of the Constitution, which is Justice Story's 3-volume Commentaries on the Constitution of the United States, which was published in 1833. Most of the first volume is taken up describing the background of the Constitution. Volumes 2 and 3 go through each provision of the Constitution and offer Story's own views about the best interpretation. In doing that, he's applying rules he lays out in Book 3, Chapter 5 of the first volume, which is the sole discussion of interpretation in the whole 3 volumes. And it basically consists of a catalog of interpretive canons that resembles nothing so much as Carl Llewellyn's famous thrust and parry inventory. It's just a big list. You know, they can be used different ways in different circumstances. The closest Story comes to anything that could be called a theory of interpretation for the Constitution is at the start of Chapter 5, in which he says, quote, "The first and fundamental rule in the interpretation of all instruments," and note that all, "is to construe them according to the sense of the terms and intentions of the parties, which is to be gathered from the words, the context, the subject matter, the effects and consequences, or the reason and spirit of the law." So not a theory, right? Just a list of considerations to look at in reaching the most persuasive reading. And this general forensic approach was applied and was universally accepted among lawyers, judges, legislators, and ordinary citizens all through the period. Now, not that there were no theoretical debates about the Constitution in the early years of the Republic. There were, but rather than fighting about how to interpret the Constitution, the big debate for the first century and a half, right up until the 1960s, was about who should interpret the Constitution, or rather who had final say over the meaning of the Constitution. And that debate started really soon after the Constitution was adopted. The original theory of judicial review that had emerged in the 1780s, before the Constitution, didn't make any claim that the court's word was final. It was enough, in fact it was a lot actually at the time, just to say, which is actually what the court says in Marbury, that, and this is the quote from Marbury, "Courts as well as the other departments are bound to follow the Constitution when doing their regular business," which in the case of courts was deciding cases, or in the 18th century phraseology, saying what the law is. In the 1790s, as the French Revolution unfolds and democratic passions grew in America, a new doctrine emerged for the first time, the idea of judicial supremacy. Now, it's just one of many efforts by Federalists in the 1790s to tamp down and control democratic politics. Remember, with respect to this, in this period, the law, including the Constitution, is decided by juries. So the idea that the Constitution was actually for the courts to rule on was a new and very radical idea. Controversial from the start, it became a major issue in the late 1790s, think of the Virginia and Kentucky Resolves, and the election of 1800, and the political resolution of that controversy was unmistakable. The idea of judicial supremacy was overwhelmingly crushed, repudiated, let's call it repudiated in 1800, along with the Federalist agenda generally. That victory was actually consolidated 3 years later in Marbury v. Madison, which affirmed the doctrine of judicial review, but did so using the language and arguments from Republican judges while conspicuously avoiding the language and arguments used at the time to argue for judicial supremacy, which makes it so perverse when Marbury is cited for judicial supremacy today. Which is why I'll also note Jefferson didn't rail against that part of Marbury, not because, like, Marshall tricked him by not ordering him to deliver Marbury's commission, like, why would that have stopped him if he wanted to do something about it, but because Marshall had actually adopted Jefferson's own theory of judicial review. And that was totally clear to readers at the time. Now, elections seldom kill ideas, although they can render them unfashionable for a time, and the concept of judicial supremacy wasn't killed, it never disappears entirely, it survived, initially among former Federalists and others in the profession, and then others as time goes on, and it remains part of the nation's ongoing political and legal discourse. So the debate over who has final say, that debate continues. Now, most of the time it's not really a live debate, because most of the time the court is pretty restrained, but there there were a few occasions on which the court did something to force the issue. From time to time, the court acted in ways that brought back to public attention the question of its authority over the Constitution. That happened, for example, in the debate over the Second Bank when Jackson vetoes it, notwithstanding that Marshall had said it was constitutional. It happened again in the debate over slavery and the territories in the Dred Scott case, and again during the prolonged period between the end of Reconstruction and the New Deal. But in each instance, once it really became a matter of focused public debate, the idea of supremacy was squelched and the court retreated. Now the point is just that no one in all of this period is arguing or theorizing about how to interpret the Constitution. Everyone accepts the kind of open-ended forensic method I described above. Instead, the debate is over who, employing that method, would have final say. And in fact, precisely because that accepted method was so open-ended and indeterminate, the stakes in the debate over who has final authority were that much higher. So that begins to change only after the court decides Brown v. the Board of Education. In the years after that, the doctrine of judicial supremacy finally achieves full acceptance in the profession and then in the wider public, though acceptance in the wider public happens more gradually and actually takes several decades. Okay, fully explaining that extraordinary development is another topic for a different day, but one obviously important source was the curious fact of the Warren Court itself, a liberal activist court that for the first time in American history gave progressives reason to see the judiciary as a friend rather than a foe. At first, liberals had a difficult time figuring out how they wanted to respond to the Warren Court, in particular Brown. They liked what the court was doing, but they and their teachers and their heroes had led the fight against Lochner, and many of them had devoted their professional lives to the idea that courts acted inappropriately when they claimed interpretive supremacy over the people themselves. Brown and the other judicial innovations that soon followed were a kind of wrenching test of the traditional liberal opposition to judicial supremacy. As Warren Court activism crests in the mid-1960s, a new generation of liberal scholars, Dworkin, Bob Gordon, others who many of you probably know, discarded the opposition to courts and embraced the notion of broad judicial authority. These younger scholars, they hadn't lived through Lochner, and to them, the so-called counter-majoritarian difficulty just didn't really seem all that difficult. Conservatives, for their part, were actually okay with judicial supremacy. It was an idea they had always embraced, going all the way back to the Federalist era, and they continued to do so after Chief Justice Warren took over. For them, the problem with the Warren Court was that its decisions were wrong. Their protests were directed at the substantive interpretations of the liberal justices, who they saw kind of falsely using the Constitution as cover to deal with matters that constitutional law didn't in fact reach or address. Beginning with Robert Bork's 1968 attack on the court in Fortune magazine, many conservatives then started using the traditionally liberal rhetoric of democracy and restraint. But they weren't arguing, as the liberals had, that the Supreme Court should defer to political bodies about the meaning of the Constitution. Conservatives continued to insist, for example, that the New Deal court was mistaken to abandon judicial enforcement of limits on federal power. And they were, and have been, perfectly willing to strike down laws they view as inconsistent with original understandings on such topics as property rights, free speech, or guns. Rather, they saw the Constitution as more limited in scope, and they objected to liberal justices using the Constitution to make policy in arenas they deemed unaddressed by the Constitution one way or the other, and for that reason left to ordinary politics. The upshot, in any event, was that for the first time in American history, conservatives and liberals found themselves in agreement on the principle of judicial supremacy. Liberals and conservatives alike now took for granted that it was judges who should do the interpreting and that the judges' interpretations should be final and binding. What they now disagreed about was how to interpret. Until this time, as I mentioned earlier, there was no special theory of constitutional interpretation, but now, with the argument over who had interpretive authority settled in favor of judges, the question of how to interpret gained new significance, giving rise for the first time to an active focus on interpretive methodology and explaining the emergence of a cotton industry to theorize about how the Constitution should be construed. Not surprisingly, judges and scholars on both the left and the right suddenly discovered that the Constitution needed to be interpreted according to unique and special rules. And again, not surprisingly, the rules each side produced were different and seemed inexorably to lead to outcomes that side preferred. Hence the rise of theories of constitutional interpretation in the 1960s and 70s, of which Ely's offering in Democracy and Distrust was an essential and prominent example. And yes, it was published in 1980, but it was based on writings that he had done in the 70s. But Ely's was just one of literally scores of efforts by scholars on the left offering theories of the Constitution to justify judicial decisions from the Warren Court era or even go beyond them. And especially the two big decisions that effectively bookended the Warren Court, which is Brown and Roe, though Ely was an exception to the latter because he did think Roe was wrongly decided and wrote about that. Scholars on the right, meanwhile, pretty quickly settled onto the new theory of originalism, named, I should note, just to come back to Paul, that was actually named as such by our own Paul Brest in his famous 1980 article, The Misconceived Quest for Original Intent. For a time, this flourishing body of constitutional theorizing led to some really interesting debates. So I was in law school, as were Jane was, Mike was. Actually, all of the speakers, maybe not Jenny, you're too young. All the rest of us I was in law school, and we spent hours, I remember as a law student, we spent hours and hours arguing about Ely versus Dworkin versus Bickel versus Raoul Berger. Were Bickel's passive virtues unprincipled? Was Ely's representation reinforcement useful maybe for enlarging constitutional rights, but not for limiting them? Could Dworkin's fit and justification be reconciled? Why not original intent, and so on and so on? But a funny thing happened over time. None of these theories on the left took. They just all sort of faded. Con law teachers might still mention them in class. I touched on them typically. But no one built their teaching around them except maybe the authors. And courts pretty much ignored them altogether except for the occasional citation for a particular argument. So too the next generation of con law scholars, which neither built their scholarship on these earlier theories nor continued to offer new ones. Instead, we basically returned to the older form of constitutional debate, arguing about whether particular decisions were right or wrong based on the traditional range of permissible arguments used in an open-ended fashion. But all that remained on the left was a vague notion that these arguments are being deployed in favor of a constitutional that is living, right, and that its meaning changes over time. And that principle is less a theory than just a way of disavowing the one theory that did remain, which was originalism, which is built on the opposite idea. The lively debates of the 1970s and 80s was then replaced by a debate over the validity or not of originalism. I'd love to talk about that debate sometime too, which in my view, and sadly, has become painfully unproductive and futile. But that's, as I say, another topic. Explaining these more recent developments has less to do with academic discourse than changes on the court. By the mid-1970s, the court had turned in a decidedly conservative direction. The Berger court stopped and began to reverse the progressive momentum built up by the Warren Court's jurisprudence. The Rehnquist court completed that process and began moving the court in a manifestly conservative direction, a development that has accelerated with the Roberts court, the occasional decision to the contrary notwithstanding. That gave a huge boost to originalism, especially as the new conservative justices, led by Scalia and Thomas, openly and explicitly adopted it as their theory for reading the Constitution. So they were deploying a comprehensive theory. As they did so, originalism changed, though, from a defensive tool to restrain expansive interpretation to an aggressively activist tool to create and justify new rights and new limitations on government. Okay, I'm going to, one passing comment here, which is because that was made easier by two practices employed by the originalist justices. First, a willingness to cherry pick and distort history as needed to reach a desired outcome. Lest anyone doubt that, I'll just say one word, Heller. Second, a willingness, when easier, to forget about original understandings if they prove too inconvenient, as we see, for example, in the cases about affirmative action and free speech. Activism is activism, it turns out, left or right, and it seldom fits any theory of interpretation. Interpretations of history are inevitably and unavoidably as living as any other interpretive practice, as any serious historian will tell you. The same move to the right on the court deflated theorizing on the left. Whether in dissent or the occasional opinion, none of the court's liberal members relied on or used any of the theories developed in the 1960s or 80s, 60s to 80s, again, the occasional citation notwithstanding. And with few or no realistic opportunities for forward motion, there was little to inspire progressive scholars to keep theorizing. All the wind left the liberals' sails, whose writings shifted mainly to attacking originalism or defending the forensic reasoning of the liberal dissenters. Now, there's more to it than that, of course. Looking at today's later panels, there may even be some stirrings from the left to reinvigorate normative theorizing. I'm actually eager to hear what's going to be there. Be all that as it may, constitutional law, I think, is ultimately just not well suited to that kind of comprehensive theorying. Like other forms of law and politics, it's just too connected to the real world to resist the need for flexibility and pragmatism in a society that itself is always evolving. And that's all.
have time for questions if there are.
I'd love to take your questions. If you'd like to queue it, one of the mics on either of the aisles, and put your questions to Larry and Jane, please.
Don't be shy.
They will cold call you.
Kathleen's just being nice, but.
Two fantastic presentations. Thank you so much. Jane, I wanted to ask you if you wanted to make your thesis a little bit more pointed. Did the Americans with Disability Act example and the example of the states that had same-sex judicial decisions being only those in which gay rights groups had already succeeded in passing anti-discrimination decisions, do you want to say that those actually refute Ely as to the political disempowerment of discrete and insular minorities? I mean, in a way, you know, Ely sort of ignores Manker-Olson and the entire theory about, you know, intensely motivated minorities having disproportionate political power. Do you think it's just bad political science and your examples refute it, or you were being gentle? And I wonder if you want to push that point a little further.
Yeah, thank you. It's an interesting question. I think what those cases reveal is the relative crudity of the claim that that Ely was making. He was saying there is a thing in the world, and that is being politically powerless. And then there's this other thing in the world, which is having, you know, ready access to the political process. And we have to figure out as to one, you know, any group, which category they're in. I think the world just doesn't work that way. And I think the marriage cases were great examples of this. There certainly were, you know, many briefs filed in those cases, especially in California. When the California Supreme Court issued a marriage equality decision, it was then met with backlash of Prop 8. But there were people saying, how can you say that the LGBTQ community in California is politically powerless? I mean, there's a list of laws. And I think and this is what I was trying to get at, is that we can't really atomize the political process and just look at it and reduce it to some kind of mathematical equation. You have access or you don't have access. I think it's much more sort of a continuum, shades of gray, and more importantly, the political process is a lot like the rest of society. And that is to say, in the marriage equality case, the fact was there was no political recourse anywhere before Hawaii for those who were claiming marriage equality. No legislature would give it a serious look. And even if there were political victories in other realms, right, what that suggests to me is that there was enduring discrimination and inability to think about the concept of same-sex marriage. So I think really Ely's focus on the political process, I think, is better understood as one site for sort of thinking about what we mean by disadvantage and inequality. And it doesn't really lend itself to precision, I think, but I do think it has to go beyond that process, because what happens in that process is itself shaped by the institutions around the political process.
I just want to, just in fairness to Ely, there's two things to bear in mind. So one is 50 years ago when he was doing this work, the state of political science itself was much less well developed on these points, and even more so, the state of law school scholarship was very much not in the way it is today integrated well with other disciplines. So, you know, the core point, the observation, the insights, so you can develop it a whole lot by what we've now learned over the course of the last 50 years and still get a ton out of it and not look to Ely to have answers at that level of understanding.
Yeah, fair.
Hi. How would Ely deal with, and how do you deal with, the Harvard case, the issue of Asian American discrimination in higher education, and whether or not Asian Americans have political power or are considered discrete and insular minorities? And, you know, how would he deal with that, and how do you deal with that?
I was going to say, Larry, I just took the other
Come on,
one.
I'm 10 years running a foundation, like what I remember from being a lawyer. You can go first.
it's a hard case because it's not the conventional case, right? Where racial minorities are all on one side. And so, you know, I think the prior panel had a pretty good discussion about how Ely would see that and where the uncertainties are. You know, I think there's a lot of factual disputes in that case, so we're not necessarily, you know, at 30,000 feet asking the question, what is the political power or lack of political power of Asian Americans? I think there's just a lot of factual disputes about how kind of the Harvard process works. But I think I certainly would not resist the idea that Asian Americans are subject to discrimination. And, you know, I'm not gonna, consistent with the answer I just gave, I'm not gonna look at that only within the four corners of the political process. I think it's a much more general kind of question. So I think that's something that has to be reckoned with. I don't have an answer for you on the case, though.
I'll just offer a couple thoughts. So first, like I say, for reasons I've suggested before, the whole discrete and insular minority framing, I think, is just not helpful. I mean, it itself, talk about an example of crude thinking about this. They had in mind one case, which was blacks in a particular structure from the 1940s and 50s, and then the notion that we're going to look at each of those words and try and think about these really complex issues. So I wouldn't start there. Second, to me, so now I'm going to speak a little heretically more as a dean, which is I think we think about the whole admissions process wrong, and that matters in terms of how we frame the question here. This kind of education needs to be thought of as a public good. It's not in the technical form in economics, but it is in the larger sense that there is a limited good that universities have to give out that is meant not just for the individual benefits to the people who get the education, but across the whole society. And so the notion that there's some legitimacy for a university, this is what's behind. So I don't start with the notion that, no, there's some right to be admitted on some concept of merit, as opposed to there's some need to have this public good distributed in a particular way, which should give universities flexibility then to construct their classes accordingly. Now, it doesn't follow that anything goes, right? But that takes you more towards an inquiry that actually does look at whether there's some intent and then some good justification for it, as opposed to just looking at outcomes and saying, since there's some racially disparate outcome and people are supposed to be getting in on this notion of merit, and that's the primary thing, and you have to justify anything else as an exception. So that's how I would think through that case. I think the courts are a long way from that. Probably most of you are as well. But again, having run an admissions process and thinking about the things that you're trying to accomplish in a class, I think that's the way we should be thinking about it.
So I had a question for Larry as to whether it is really true that we have returned to the sort of longstanding eclectic approach to legal constitutional interpretation, especially that you describe. And I really wonder, because when you look at even the passage the description of that you read begins by saying, well, we look at the words as they're commonly understood. Well, that sounds an awful lot like original public meaning. And then we look to the intent of the legislator or the framers. Well, that looks a bit like original intent version of originalism. And then maybe we look at the purpose, the evils that are being combated, and that looks a lot like what we might call today purposivism, right? But what you don't see, and then you look to longstanding interpretation by both, especially courts, but also other branches. What I think you don't see is a sort of straightforward, unapologetic, explicit normative claim, that is, that we should interpret the Constitution to make the country as best, like to talk about, use Dworkinian language, the best that it can be, like strong views of equality or justice or efficiency that don't arise from the textual historical traditions. All of those traditional sort of eclectic, flexible things seem to be, in a sense, sort of backward looking. They all look backwards rather than being, highly instrumental and transformative. And that seems to me, It's not that those things were never in place before, but it does seem to me that that way of thinking came into the fore in the Warren Court era and has never gone away. And that still seems to me to be, it's not usually justified in theoretical terms. You don't, Dworkin certainly tried, but isn't that still with us?
Yeah, maybe I was a little unclear. So here would be my claim, which is what you described. That was always the practice. They're not all backwards looking, because also included were the policy consequences of different interpretations. That was also one of the things. And the forensic method that was always the practice was one where you could look at all those things. It wasn't in a particular order. They weren't particularly structured. It was a kind of all things considered. You'd put them together to what seemed to be the most sensible interpretation in a particular case or of a particular clause. So that was the method. And I mean, one thing you're saying I agree with, which is that was primarily the method of the Warren Court justices themselves. Not surprising, because they came out of that tradition. What my claim was, though, was that two things changed in that era. One was the court's claim to supremacy in the wake of Brown took on the left, basically the left flipped. Two, as it took, and they were deciding these cases that really stretched the Constitution in new ways, that created a strong need to justify. And out of that need came this debate, we really need to focus on how the Constitution is interpreted. So scholarship develops in that period that is making these kinds of comprehensive theoretical moves, trying to give you a comprehensive principle that you can use to interpret that's something different than the all things considered. And there's this flowering in that period that's what Ely is a central piece of. That's what he's doing. That's what Bickel tried to do. That's what Dworkin definitely was doing. Originalism, Bork Scalia, God, so many of them, right? Michael Perry. I mean, I think of all the stuff I was reading in that course, and they were all but that attempt for comprehensive theory turns out to be short-lived. And so what we're back to is what was the traditional practice, with the exception of originalism. Because originalism, which was one of the things that you would look at in the traditional theory, is at least offered and defended as the sole interpretive guide. Doesn't matter what the policy consequences are, along with textualism, but of course we're understanding the text in light of what we look at history and find to be the original public understanding. So that is an overarching comprehensive theory that's supposed to guide interpretation in every case and across every clause. That's the only one that is left standing of that period. And on the left, as I say, we're mostly just back to what was the traditional, trying to justify the outcomes by a kind of all things considered that can draw on any and all of these, depending on what makes the most sense to the writer and to their efforts to be persuasive.
Dean Kramer, thank you. I'm very interested in what you described so eloquently as a flowering of sort of meta-interpretive theory in the wake of a more activist court. Considering that the judiciary has changed considerably in the recent past, do you see such a flowering happening again at any point in the future? And do you think that there is a situation in which a similar need for theory would produce similar academic output?
That's a wonderful question to which I don't know the answer. What as I say, my own view suggested at the end is I actually think legal interpretation generally doesn't and shouldn't lend itself to that kind of thinking. That one of the reasons I was attracted to law and I stuck in law school was it was that wonderful fact that it was intellectually super engaging and theoretical, and you had to think about all those things, but that ultimately you had to ground it in the world. And the intersection between that is what makes law so great and so important, and is why it's always changing. And I just don't think that kind of world, given the way societies are constantly evolving, and devolving might be right these days, evolving and developing, is well suited for any kind of comprehensive overarching theory. So that would be my own view, that it's not a good way to go about this. Whether it will, as I say, you have one, and it is dominant. Originalism is absolutely dominant. And again, I think that's a terrible theory, but that's another talk. No, by the way, I shouldn't say more terrible than any of the others, just terrible for different reasons, in my view. But I mean, again, there are people making those moves, and I am always open to, I'm eager and interested to see. It's been a while since anybody has really tried that kind of comprehensive theorizing. I think a lot of us felt a little sheepish about it after a while. I know I did. I never did it, so maybe that's why I felt sheepish, didn't want to try. Never say never. As I say, I don't think it's because of the change in the political ideology in the court. To me, what drove it was the change that mattered was the shift from arguing about who should interpret, because the method was open-ended, to acceptance that it was going to be the court and their word was going to be final, and that then put a lot of weight on the how, because that's where the disagreements would play out then. So that shift has taken place, and unless we go back on that, then, hard to know.
Well, one thing that I think will ascend, and I'm surprised Larry didn't mention this, is kind of resistance to judicial supremacy, because I think the progressive wing is kind of coalescing around an idea that you were controversially touting 20 years ago, which is maybe we should be a little worried about judges having the final word on all these important issues. And I think it's not an accident that progressives would come to that at this moment in time. It's not a sort of a pure theoretical rethinking, but I think that you might see more attention paid to the resistance to judicial supremacy and to forms of popular constitutionalism. Now, that's not a comprehensive interpretive theory, but it is does have a central point about how to approach the Constitution.
Yeah, and I should say, you're seeing it, except what history does teach us is that only happens when you have two things true, which is one party or one side has strong control of the political branches, and the court is in a very different political place and then moves on that. If you look at each of the incidents where that happened, as long as you've got either divided government or a closely divided country, there will never be the political will to actually get the action. I was interested in the Biden commission on the Supreme Court, not because I thought he was ever going to take any action. He wasn't. It would have been crazy for him to do so. But because it begins to re-socialize. See, one of the other things, what did it mean to accept judicial supremacy? It literally meant the delegitimation of all of the devices that had been used all through history. So court packing was done a lot through American history. So was not a lot, but jurisdiction stripping, budget, all these things were done. And what the embrace of judicial supremacy meant was the delegitimation of those devices, that you couldn't do that because even though the Constitution clearly allows them, they're too big a threat to judicial independence. So it's re-socializing the possibility that those things aren't wildly unconstitutional is beneficial. And then if the day comes, and by the way, again, it can happen either way, but just when there's that division, you'll see, I think, then the pushback, because the political system will not really stand for letting a bunch of judges, and the idea of judicial supremacy itself is a thumb on the scale, like making that argument that, no, it's not your job to know the Constitution, that was given to the courts, is itself a device for pacifying political opposition.
So since you're about to turn, the next panel will be on the new generation of constitutional scholars. Look back to one generation before you. When I was in law school, Herbert Wexler's Neutral Principles of Constitutional Law and then Alex Bickel's Least Dangerous Branch were what we were taught at Harvard Law School. Actually, Bickel came later, but it's part of that generation. Can you put Democracy and Distrust in the context of those two very important articles for its era?
So as I said, in the early years, the older liberals really were troubled by Brown. They liked the outcome, but it really was contrary to what they had believed and fought for their whole lives. And so Wexler, and yes, Bickel also, right? They're really trying to find ways to justify Brown without accepting that notion of judicial supremacy and the judicial activism that it potentially opened up. Ely is part of the later generation, but clearly troubled in the same way. So just within that range of liberal scholars, he was more concerned about the anti-democratic implications of judicial supremacy than Dworkin or Ackerman or most of the other later theorists. And that's why you see he's the only one. He's like, nope, Roe is just not rightly decided. I can't get there on any principle that I can come up with, right? And of course, he took a lot of grief for that, I think. So he's part of the later generation, trying to come up with a comprehensive theory, but a little more willing to limit where it would take the court because of that concern than most of the other theorists of the later generation.
Time for one more question? Yeah.
So this is kind of a follow-up from the question before, but I'm just wondering if this moment of sort of more progressive meta-narratives, larger theories about the Constitution ever really had a political moment in the same way that there was this debate over who gets to interpret the Constitution. I'm thinking about, like, in the Ed Meese papers over here, they had, his originalist DOJ had their responses for Dworkin and Ely written in there, but never really had to break them out because no one was really talking about it politically. And for them, it was always characterizing the Warren Court as pragmatic sociological law. So did that moment ever really happen politically, that where originalism beat out these other theories? Or is this something that still hasn't occurred? And if so, would it potentially give better outcomes than a sort of pragmatic law that originalism seems to have politically at least won out on?
Conservatives are so much better than progressives at consolidating around something, right? So you know, the consolidation around originalism and the breadth of support for it, I think really doesn't have a parallel on the other side of the aisle, or the other side of the judicial, you know, aisle or philosophical aisle. You know, Ely, I don't think was sort of, I don't think Ely's theory was quite comprehensive in the same way. It doesn't apply in a lot of instances. It has a particular democratic theory. It picks out two different malfunctions that it's interested in, and it talks about that. You know, originalism is much more, I think, comprehensive. So I think there's a sort of differences between these theories and also differences in the kind of communities that are rallying or not rallying around.
So first, I actually think one of the reasons there was this consolidation around originalism as opposed to the others is because, although, you know, it doesn't actually have to be attached to somebody else. If I'm a scholar, like if I decide to embrace originalism, it's not that I'm like following, you know, Nino Scalia or Raoul Berger or for some reason, right? Because of the nature of that theory, as opposed to any of these other theories, like no self-respecting academic wants to be applying Ely, right? You need to be your own thing. I actually do think that was a big part of it, at least in the academic world. The political moment for that kind of theorizing did look possible, at least in the law schools, I think in the late 60s and early 70s. I mean, there were powerful arguments for making, you know, poverty, or not allowing poverty as an established constitutional right, these arguments to really push the education, all sorts of stuff. It just didn't take. Now, partly, of course, Warren resigns, you know, within a couple of years, Nixon gets 4 appointments very quickly on the court changes. That's why I do think that's the biggest. I doubt it would have ever gotten that far because the country was nowhere near prepared to go as far as that and so on. So probably not. But again, I think at the end of the day, the pragmatism is always the driving force. As I say, you look at originalists, you know, their results may tend to the conservative side of the spectrum, but you can't get too far. And if you do get too far away, it won't take or last. I just think that's, you know, that was the point I was trying to make. Originalism is as much a living constitutional theory as any other because people's interpretations of the history just change as they go along. And I just think that's unavoidable, and we might as well just acknowledge it and be open about it.
Thank you very much, Larry and Jane. We're going to have a brief break before the next panel, but it's going to be brief, and then we're going to get started on time so that they have time to present their ideas.